Hi, today I am in Barbados. What is the most important thing you should know about Barbados? Particularly if you are a human rights lawyer or a victim of breaches of human rights. It is the case law Bredshaw versus Barbados of the Committee on Human Rights of the United Nations. So the United Nations Human Rights Committee, in the case Bredshaw versus Barbados, has decided that all its interpretations of the Covenant on Civil and Political Rights are binding, that the state party must implement all its views, decisions on the breaches of human rights. So we have a wonderful document which is called Covenant on Civil and Political Rights, and that document provides a huge number of wonderful rights, and if those rights are breached by the Supreme Court of your country, by the court of final instance in your country, you have the right to lodge an appeal, a communication with the Human Rights Committee of the United Nations, and that committee performs the role of a court. So where it is written that that committee performs a role of a court when you complain about the breaches of human rights, it is written in the case Bredshaw versus Barbados, and the Parliament of Barbados is behind me. Case number 489/1992, paragraph 5.3. Let's read it together. By ratifying the covenant and the optional protocol, Barbados, or your country, has undertaken to fulfill its obligations thereunder and has recognized the committee's competence to receive and consider communications from individuals subject to its jurisdiction who claim to be victims of a violation by the state party of any of the rights set forth in the covenant. While the covenant is not a part of the domestic law of Barbados, which can be applied directly by the courts, the state party has nevertheless accepted the legal obligation to make the provisions of the covenant effective. To this extent, it is an obligation for the state party to adopt appropriate measures to give legal effect to the views of the committee as to the interpretation and application of the covenant in particular cases arising under the optional protocol. This includes the committee's views under Rule 86 of the Rules of Procedure on the desirability of interim measures of protection to avoid irreparable damage to the victim of the alleged violation. In other words, I don't see how some people might argue that the views of the committee are recommendations, that they are not binding. We have an effective case law that says that everything what is decided by the committee is binding. We have this case law from 1994. Subscribe to my channel.